We are back on Morning Line. Thanks for joining us. Nick Barris along with News Channel 5 legal analyst Nick Leonardo. If you want to jump in, any questions, there's a big hearing today in the Vanderbilt rape case. 615-737-7587 is the number if you want to jump in. And got a couple of emails from folks. One email from Jimmy asking why couldn't they use the alternate jury or alternate jurors or whatever they had in place the first time around. They were already dismissed, right, when this came about?
That's correct. You know, in a case like this, there's usually at least 2 alternates selected.
Yeah, and it's only 2 anyway.
Right, and so, you know, once the jury starts deliberating, those alternates they're cut loose and they're sent back home, they're released. And so, you know, there was no indication that there was going to be a problem with this particular foreperson or this particular juror until after the alternates had already been cut loose. So at that point, you know, we didn't know that there was any kind of problem until after the verdict had come down.
I gotcha. And Corey is saying this is just a joke. I mean, so many people are frustrated that this whole process is coming about that's going to cost so much money. These guys have already been convicted once, thrown out, and again, as they sit now, they are innocent until proven guilty all over again, right?
That's exactly right. She's the alleged victim. They're innocent until proven guilty. And that presumption of innocence travels with them throughout this process. And I think you're going to hear a lot about that in voir dire, which, you know, any good defense attorney will talk about, the presumption of innocence and how, you know, basically everybody, when they're going through jury questioning, when they're asked, you know, let me see by show of hands how many people would think these folks are innocent as we sit here today. Everyone's hands should go up because they are presumed innocent.
Right.
Okay? And some lawyers will even say, you know, Mr. Barris, who do you see sitting here? And innocent or guilty? Innocent. Make you look at the defendant and say he's innocent.
Yeah.
Because that presumption does travel throughout this process, and that's something that you want to make sure that you can get a juror that understands that and is willing to abide by the law. And this is going to be a tough one. Even though they're going to Chattanooga, they got a better shot. But again, because it's intertwined with SEC football, Division I athletes, it is a national story.
Yeah, it is interesting when you think about, you know, we're around it and we follow it here, but you think about and wonder about the possibility of jurors knowing about it. Last time I went to Chattanooga for a jury selection was in the Perry March case, which huge case, you know, 48 hours at a lot of it. And most of the people there in Chattanooga had no idea who Perry March was. I think they selected a good jury that came back here for the trial. Even you ask some people locally here, Mary Elena and I were talking, and they more or less just said, yeah, you know, we have a situation here where you know, you ask people about the Vanderbilt rape trial, and people don't pay that close attention. We have a lot of people that will follow the gavel-to-gavel stuff, but in Chattanooga, I won't be surprised. You're right about the Southeastern Conference football angle, but still, I won't be that surprised if they have people, when they're asked, how many of you have heard of this, say, I have no idea. It's Chattanooga. You know, if they didn't see the national news coverage, I don't think it's got a lot of play in the newspaper there or on TV.
And maybe that's a reason we haven't seen any action against this foreperson, because that's just going to create more of a media frenzy. It's not every day in America that a former foreperson of a jury gets indicted for an action committed while in the service of being a juror. So maybe that's another angle.
Oh, that's a good point. Maybe they don't want any more of that publicity. Is there also anything to this that, again, the circumstances behind why he didn't reveal that he was a sexual assault victim himself at an earlier time was a statutory rape? Maybe he didn't consider himself a victim. But also beyond that, if you go after prosecuting a prospective juror, does that chill other jurors to some degree? I don't buy that argument myself, but, you know, we depend on the jury system. We depend on people coming forward. If they come in realizing, gosh, if I make a mistake here, maybe they're going to prosecute me, you know, does that send a wrong message to prospective jurors?
Well, I don't think so. I think that that's a message that needs to be sent.
Yeah, that's what I think.
And also, it's not that I might make a mistake. There's no mistakes. This individual lied, okay, and was dishonest and had an agenda. So it's not about, you can't make a mistake as a juror. Just follow what the judge tells you to do. Don't talk about the case with anybody else. Don't talk about it with the other jurors until the judge gives it to you and you're allowed to deliberate. And as long as you follow that rule and you show up in your own time, you're not going to have any trouble. And I think that we live in a society nowadays where, you know, if you're on a big jury like that, then, you know, there's a potential book deal. There's a potential, you know, you can run the media circuit. People would actually potentially pay you.
There's incentive to lie to get on high-profile juries, maybe.
Well, and think of the Casey Anthony jury. I mean, you know, I promise you that, you know, that some CBS or other affiliate, you know, national level would pay to get you to come on to talk about your experience as a juror. And so we need to send a message to people that this is very serious business, and don't just get on a jury because you think that at the end of the day that you somehow could benefit from it because it's a high-profile case, and that's the wrong attitude to have.
The wrong attitude to get on there. So So at this point, yeah, I think you're probably right. He's not going to face any criminal charges, at least not. I don't know if there's a statute of limitations at some point, but for deliberately lying, not likely, right?
You know, again, that's the determination that will have to be made by, you know, the district attorney's office, and I don't want to pretend to be arrogant enough that I have any idea as to what the district attorney's office is thinking about that.
What about, to avoid this from happening again, you mentioned it earlier, just to let people know, the questionnaires is one of the suggestions in the motion, saying let's hand out questionnaires to all these jurors in Chattanooga ahead of time.
Yeah, to hand out some written questionnaires, and I would think that maybe, you know, some of the questions would have to do with the pretrial publicity, but I think a lot of the questions would have to do with availability, you know, and that may be something that the court on its own initiative could hand out questionnaires, because, you know, we don't need to bring people in who are single parents, let's say. I mean, there's no way they could leave and come to Nashville for a trial. I mean, there's no one to take care of the children, and or maybe someone with health problems that can't get away from home that long. So it's a good idea to go ahead and narrow it down, because what we're looking for is, you know, jurors that can be absent from their lives in Hamilton County and be carted down here to Nashville and cut off from the world for 3 weeks. And you're just not going to find a lot of folks that have that availability. So if you can narrow it down, by the time we put those people in the chair, we already know they have the availability. They already know that there's no pretrial publicity. Now let's talk about, you know, presumption of innocence.
I want to remind you, at 9 o'clock, we will take you into the courtroom over there. It's expected to begin right around 9. Monty Watkins is usually pretty good about that. And we will have that gavel to gavel for you in this hearing to let you know exactly what happens with all of these motions. You suspect Vandenberg and Beatty probably won't be in the courtroom. I don't think Vandenberg. I think he's been given waivers, so he doesn't have to make that trip back and forth all the time from California. Beatty could be there if he chooses or not. He still lives in Nashville.
That's correct. I mean, these are legal arguments, you know, and in criminal court, it's not like, you know, divorce court. It's not like any kind of civil court over car accidents or being evicted or even orders of protection for that matter. I mean, you must show up in criminal court unless you get a special kind of dispensation or waiver from the judge, you know, and especially when it has to do with a legal argument. You know, these are nothing but legal arguments. And then you have some other additional ancillary facts, such as that Mr. Vandenberg lives on the other, you know, side of the United States. You know, I think he would waive his appearance for this sort of hearing if that is requested.
And my understanding in all of these hearings to this point, too, we have not heard from or have not seen the alleged victim coming in. And my understanding is she's now moved on with her life, is out of state, pursuing higher education there. But that she'll have to be back. Would she be back for jury selection? Would she want, or is that her prerogative if she wants to be part of that or any of that? No necessity for her to be here.
No necessity for her to be here. There's no necessity for her to ever be here unless she is subpoenaed by either the defense or the state. If she's under subpoena, then she must show. But again, we don't want, you know, she's the alleged victim, and we don't want to, you know, put her through any more turmoil or strife than she's potentially allegedly already been under.
You believe, though, that she will, if this goes to trial again, testify again?
Yeah, I think she did a good job. I mean, what I heard last time, and I think that's, you know, they didn't run any risk by her testifying. I think she remembered some things, I think, that were beneficial, and so I think she'll definitely be back. I know that she's willing to come back, but again, you know, if, you know, are these individuals willing to entertain any sort of jail time, and if so, is the victim okay with that? You know, is she okay with them doing 6 or 7 years in jail?
Right, and they would take that under consideration. They would run it by her.
Sure, that's
and she would say yes or no, and then they would consider it. Doesn't mean they have to follow that, but certainly they want to be sensitive to what she feels comfortable with.
And that's the right attitude. But a lot of times you might have, let's say you have a victim's family who says, no, I mean, you got to go for the death penalty. You got to go for the death penalty. And it was an accidental death or something, you know, manslaughter, criminally negligent homicide. So, you know, the tail doesn't wag the dog. But the state does do a good job. They have victim witness coordinators who do speak with victims. The DAs themselves speak with these victims, and they talk about, these are our strong points, these are our weak points, these are why I think we need to accept this offer, extend this offer, or take it to trial. And so they're very much so intimately involved with the decision-making process. But when it comes down to legal maneuvering, preparing for evidence for trial and stuff, that's up to the district attorney, because they're the lawyers in the case.
Let's go to Kim. Good morning, Kim.
Yes, I had a question.
Sure.
You know, it seems like to me that these guys have already spent 3 years of their life tied up in this whole thing, which they paid a partial price. It just doesn't make any sense that they don't go ahead and do some sort of plea deal that's a reasonable amount of time and get this thing over with, because it's obvious that they're going to be convicted again. And, you know, I don't think they have any chance of getting out of it with that with that video, and it just doesn't make any sense to me to spend all this time and all this money. It seems like to me it's almost a political deal on the part of the state wanting to get all this publicity for women's groups or something, because it just doesn't make sense. When you look at all the plea deals being given to murderers and everybody else, and these guys are being held to this, it just doesn't, I just think it's political.
Let me ask you, and I hear you talking, what do you think would be reasonable, do you think?
I think after they've already spent 3 years, maybe a 5-year, 6-year deal, instead of getting 15 or 20 more years.
Okay, fair enough. Listen, now I will say this, at least the first time around, I mean, from what I understood early on the first time around, a deal can be offered. That doesn't mean the defense is going to take it. So we don't know who's saying no to a deal. And I can tell you this, and you remember when the verdict came down in the courtroom, and Brandon Vandenberg and his attorney Albert Perez both were just like stunned, as though they were waiting to hear that they were not guilty. I mean, I think even the most, conservative person watching this, after watching that trial, would have to agree, after seeing what we saw, those two defendants were going to be found guilty of something. Maybe not the most serious one, the way it came down, but of something. To be sitting there and thinking you're going to be found scot clean after what we watched, you're in a dream world, all right? And so I just wonder if perhaps they're sitting back right now and thinking the only reason they were convicted is because of this juror and he influenced everyone else, and that's why it came down, which if they think that, they're dead wrong. That's what makes this such a travesty. If that juror who had the misconduct wasn't there, I am utterly convinced that there had been another person who did it right, the verdict would have been the same. I don't believe he influenced these other jurors at all. I just don't. But what do you think? I mean, what's a fair sentence for these guys? And would they even accept it if there was a reasonable offer from the prosecution?
The state's got a strong case. We've seen that.
Yeah, so why?
And the only thing that's going to make the state's case stronger is knowing how Judge Watkins is going to sentence these individuals. If they're discussing right now, if they're discussing a 10, 15-year plea deal, but if you knew that Judge Watkins, was going to run a couple of these counts consecutive, then obviously your offer, if you're the state, it's going to go up because, the exposure, you have an idea what the judge is going to do. So I think that, whatever's fair, I don't know. I will say this, that a settlement in any kind of legal case leaves both sides a little unhappy. So, if you were somewhere around the 7-8 year mark, the state feels like they could have gotten, more out of it. And, of course, the defense is unhappy because they're actually going to jail. But remember, maybe they're thinking that that all they need is to get a hung jury. If they try these things again and it's a hung jury, then obviously, they're willing to take less time because they feel like they're making, more progress. So, it seems as though plea negotiations really start to heat up, if there's going to be any, the closer it gets to trial, and closer it gets to D-Day, if you will.
So as we go to the break, Kim, just to say to you, we don't know who it is or what's going on behind the scenes with the plea deals. And so who knows? Prosecution could be trying to make one, and the defense may say, nah, we think we're going to win this, and refuse to take it. So we just don't know on that. So it's not necessarily fair to say, it's political on one side or the other, because we don't know what's going on behind the scenes. But it could go from either way.
Well, I don't think the state's, knocking on their door saying, hey, guys, we want you to take a deal, because they know how strong their case is. Like I said, the only piece missing from their case is how's the judge going to sentence them.
And a lot of people saw that evidence, know how strong it is, and if they enter into some plea that's just, a slap on the wrist, I think a lot of the general public's going to be like, what are you doing? We saw the video. You're giving them something this small? So, they've got a lot of things to consider. We'll take a break. When we come back, as usual, around 8:30 or so, the calls pick up. And Christy, Cindy, and others stay there. We'll get to you right after this.